This is a subject that I could probably speak about for the next 3 days. So I will just carry on speaking until I'm told to be quiet. It's a subject that I could speak about for a long time because there are a lot of issues connected with what I'm about to speak about. And it's something that I've become quite passionate about. Hopefully the mechanics of the presentation will actually work. Hopefully my time won't be penalised for the fact that it's not working. I'll just give a very quick background about myself whilst they're doing that. I'm a British barrister from the United Kingdom. I specialise primarily in international law. I'm not a human rights activist. Human rights law is a part of my work, but as I say, I'm not an activist. I work currently in the field in a number of different countries, including Bosnia, Bangladesh, Syria, Ghana and Thailand. Bangladesh and Syria are the two cases that occupy the majority of my time. In Syria, I act for the opposition and I act for victims. And in Bangladesh, I'm engaged to represent a number of individuals who are part of an Islamic political party that have been, in my mind, subject to a witch hunt by the current administration. Now, I've been heavily criticised for a lot of the comments that I've made. I've been thrown out of Bangladesh. I'm not allowed to return. They refuse to give me a visa. And so I effectively have to advise my clients, who are all in custody, many of whom are in custody for 18 months without charge, in a process that, according to the United Nations, is arbitrary and breaches international law. This is one of the titles that we've come to give the International Crimes Tribunal in Bangladesh, a wolf in sheep's clothing. We call it this because bringing an end to impunity is used as a way to put on a process that breaches very basic standards of due process. It stopped working again. If you could just turn it to the next slide. This is a statement that was made by the Prime Minister of Bangladesh when talking about the establishment of the International Crimes Tribunal. And the important point is underlined when this action or this process is in accord with the rule of law. Well, that's the rhetoric that is adopted by the government. 10 minutes. Now, what we mustn't forget is that there was a very brutal conflict in 1971, where a large number of people lost their lives. People were tortured, raped, and a number of individuals must face trial as a result of that conflict. As an international lawyer, I strongly believe that these matters must be the subject of a proper judicial process. I spent 8 years in Bosnia working for the prosecution because I strongly believe that these matters must be the subject of a proper judicial process. Because if they're not, the horrors of the past will continue to haunt the present, and there can be no stability and no reconciliation until these matters are dealt with. After the conflict of 1971, there was a process set up by which a number of individuals, primarily prisoners of war from the Pakistani military, were to be put on trial. But as a result of a tripartite agreement between Bangladesh, India and Pakistan, this process was effectively put to an end. And nothing happened for 40 years, until the current administration, the Awami League government, decided to reopen this process and establish an international crimes tribunal under the legislation that was drafted in 1973. Now, that very process has been criticised. I do not criticise that process because Bangladesh, as I said, has an obligation to deal with this. but it equally has an obligation to do it properly. It has an obligation to do it according to national and international law. And any process that it sets up as a civilian court, because in 1973 we were talking about a military court, now we're talking about a civilian court that is only set up to deal with Bangladeshi civilians. But more worryingly, it is only set up to deal with one side of the conflict. Only those who opposed independence will ever be put on trial. Anyone who fought for independence, irrespective of whether they committed an offence or not, will never face trial. So, in that way, it is arguable to say that the process has a discriminatory intent. You also have to look at those who are subject to allegations, those who are in custody. They are all members of the two opposition political parties, without exception. Now, it would take me a very long time to go through all the criticisms, and I appreciate the writing is very small, so I'll try and read it out from here, but these are very, very important. The legislation, as I said, comes from 1973, at a time when the only real basis to rely on were the Nuremberg principles. International law has developed significantly since that time. The current legislation provides no real definitions of crimes. We have repeatedly asked the tribunal to address this. It has failed to do so. Domestic laws are excluded. Criminal procedure and criminal evidence laws that apply to every other criminal case in Bangladesh is explicitly excluded. International law is excluded. The tribunal has adopted a procedure by which international norms do not apply. They only look towards their act. Now, that means when we're looking at the nature of the tribunal, whether it's an international or a national tribunal, that's an important thing to look at. If international laws do not apply, and it was not established under an international agreement, it cannot be considered to be an international court. And it is not. That would mean, therefore, that it's a domestic court. But then, due to the fact that fundamental guarantees under the Constitution are explicitly excluded, domestic procedural laws are explicitly excluded, there is no right of appeal of any decision of the tribunal, there is no challenge to the legislation, there is no challenge to the appointment of an individual judge. It begs the question, then what is it? In my view, it's an extraordinary tribunal.
Yes.
Because it's only applying a law and no other domestic and international law or practice. And that is a very dangerous precedent to set, particularly in a volatile region. It is a dangerous precedent to set when we look at other regions such as Sri Lanka, Burma. A lot of these countries could be spurned to create tribunals of their own. And that's why I've repeatedly said from the outset that it's a dangerous precedent to set. Now, as I said, I'm part of an international conspiracy, it seems. I've been accused of being part of an international conspiracy. Now, if striving for a fair trial, striving for fundamental rights to be protected to those accused of the most serious offences, if that is an international conspiracy, then I'm guilty. But I'm not alone. This list also a number of individuals who must also be part of this conspiracy. The United States Ambassador for War Crimes, the International Bar Association, Amnesty International, Human Rights Watch, all of these organisations have criticised this process.
Yes.
And these as well. Now, There was a comment recently by a member of the Bangladesh government, the State Minister for Law, and he said this will be a shining example to the world. I agree with that. It is a shining example to the world of what not to do. Here are the comments that we make. Politically selected targets for prosecution. Now, I'm not saying that this is a politicised process. I've been asked to say that on many occasions. Some of the journalists in this room today have asked me to say that. I'm not going to say that because it's not for me to say. But the appearance is that it is a politicised process. There is no independence from the executive, from the government. The judges, prosecutors, investigators are all appointed directly by the government. There is no objective impartiality. The investigations are conducted under a cloud of secrecy. Our clients were interrogated by the investigators in the absence of counsel. We asked to be present and we asked to have advance disclosure. We were denied that right, because in Bangladesh it doesn't apply. When the first accused, Mr. Saidi, was brought into court and he was presented with the list of charges of crimes against humanity and genocide, he was asked to enter a plea. That was the first time he'd heard these allegations. He asked, well, certainly his counsel in court, not me because I'm not allowed in the country, but the Bangladeshi counsel who was in court, asked to take instructions from his client, as you would expect in any normal system. He was told, this is not a matter for counsel, this is between the court and the accused. And he was required to enter a plea there and then. Now, our counsel, and I appreciate I have to finish very quickly, our counsel have been subjected to pressure. There have been threats of violence against them. Witnesses have been intimidated. Again, that's not me saying it, that's Human Rights Watch. No privileged communications. The communications that our Bangladeshi counsel have with their clients are under the watchful eye of the intelligence services. We could have no privileged communications with our Bangladeshi Defence Counsel. We couldn't train them. And you mustn't forget that this is an area of law that Bangladesh has little or no experience in. It's a very complicated area of law. So we decided to train and spend a few days with our Bangladeshi counsel outside of Bangladesh in Kuala Lumpur. I was followed during the 3 days in Kuala Lumpur by Bangladeshi intelligence officers. They attempted to enter our conference room at the hotel to peruse our papers. Now, my final comment, and then I will sit down, and I'm quite happy to answer any questions, is that the government has repeatedly said that this is an independent process. This is a transparent process. So my call to the Bangladeshi government is, okay, then show that. If you want this to be a shining example to the world, and this has particular resonance in America, because America is against the International Criminal Court, and regional domestic courts are potentially the answer. I'm not siding either way, but if that is the position we take, then we need to provide support to countries in transition, because unfortunately, after 41 years, Bangladesh is still a country in transition. We need to give them the support they need, and the government needs to accept that. The United Nations offered support to Bangladesh in 2009, offered support by way of international participation. They refused. We are now entering a very dangerous period for Bangladesh. It needs to accept that these trials have greater significance than the next election. Thank you.